Good morning. Strategic divorce planning has been around since 2013. It actually has a really great relationship with vested divorce. Vested has also been around since 2013. And strategic divorce planning is a very specific type of company. Strategic divorce planning is focused in on the financials of people going through separation and divorce and post divorce. What makes SDP, strategic divorce planning, special is that it is a full service financial planning service company for the divorce industry. What do I mean by that? First of all of the financial advisors are certified divorce financial analysts. So, certified divorce financial analyst is a phenomenal certification that financial advisors, attorneys, divorce coaches, you name it, anybody can get that certification. But it's a great certification for the divorce industry because it just deals with the very specific nuances of the finances in dealing with divorce. Now, we at Strategic Divorce Planning are focused in on CDFAs that are also financial advisors. Why? It's a really important factor. An attorney, a divorce coach, a real estate professional, or a mortgage professional can get the certification. But when you're dealing with the division of assets, involves different types of products and services. And it's really important to understand those products and services from an investment standpoint, from an ability to have access to dollars and so forth, from a taxation standpoint. And financial advisors tend to be more suited to identify and understand those products and services better than the other professions. I'm not saying that the other professions couldn't ultimately figure it out with a lot of digging, but the financial advisor is really going to hone in on that and save you some time and money doing it. So our firm really does focus in on making sure that we have financial advisors as CDFAs. We do have a couple of accountants that are CDFAs as well. But what else? So what does a strategic divorce planning do? The first step, they are involved with figuring out the division of assets for our clients. And sometimes that's for just an individual or it's for the couple working together and doing an actual financial mediation for the division of assets. But we come down to a process with our clients to answer three questions. And the questions are, where is everything? Where we gather all of the facts and figures and so forth that is really important. And I'll tell you, probably the most important part of your negotiation is to understand where everything is. The second question is, what's it going to look like on day one of your divorce? And basically, where am I living and how am I affording that? What's my quality of life look like? And then third, what does it look like 10 to 15 years down the line? These are some of the most important financial decisions you'll ever make in your life. And it's going to have an effect, not just today, but 10 to 15 years down the line as you're bumping up against or going into retirement. So as CDFAs, we work really hard at answering those three questions. And by answering those three questions, you can then create a proper negotiation with your legal team, whatever legal strategy. We work with the legal teams. We work with all the attorneys, no matter what process, whether it be litigation, mediation, collaborative law. And again, we will work with couples if they are working on doing this themselves to do that as well. So that's the first step that STP does. The second step is that there are lots of different things that could potentially be involved in your circumstance. One is you might have a pension. Well, we do pension valuations. Another one is you may have a business. Well, we do business valuations. And then third is, which we see a lot of, is clients saying that I think my spouse is hiding something, hiding money, hiding assets, hiding whatever. And so we do forensic work to uncover that. But we also do something very important, which is called pre-forensic work. And that pre-forensic work is just really determine whether you should spend the dollars on really doing the forensic work, because it's very expensive to do that forensic work. So we do a pre-forensic work to say, are there any red flags, et cetera, et cetera. But all of that, and including that, we also have our company is affiliated with trust firms to do the estate planning and any creating new wills and trusts associated with the breakdown of a marriage and then going into divorce and post-divorce, et cetera, and all the different steps. And you're going to hear about a bunch of those here today. So when you're hiring, STP is the most unique financial advisory firm, certified divorce financial analyst firm in the country, because we do all of it, all in-house, versus piecemealing it out to a pension valuation, piecemealing it out to a forensic CPA, piecemealing it out to a business valuation. It's all kept in-house, and that helps save time and save money in your process and ultimately gets the best results. And just one last thing that STP always mentions as a part of this is that those 3 questions that I just mentioned, if you do not have the answers to those, you should never sign your divorce agreement because you're signing an agreement that you do not know how really affects you. So even if you're at the last stages and you're ready to sign your agreement, if you don't have the answers to those 3 agreements, please don't sign that. Make sure that you have the answers to those agreements. So that's SDP. SDP works in many of the hubs that Vesta is involved with across the country, but we also work on our own throughout the country, dealing with people going through separation, divorce, and post-divorce. Today, we're going to be talking about estate planning as a part of the divorce process, and it's really the do's and don'ts. And we get a lot of questions around that. Glenn Crawford's going to talk a lot about that today. I will be joining him on that as well. And also, Susan Trotter is here to talk a little bit about from a divorce coach, life coach, and relationship coach standpoint. And so before we get going on Glenn's presentation, turn it over. I would actually like you to meet Mandy Barr, and Mandy is a relationship manager for SDP. You might know her from Vesta, so she does some work with Vesta as well. But she's also going to be involved with contacting you after these events to find out what you liked, what's going on, how can she assist you, et cetera, et cetera. So Mandy, it's like,
Yeah. Thank you so much, Bob. Hi, everyone. My name is Mandy Pullenbar, and as Bob says, I have the pleasure of working for SDP. And it is really my goal to help to get to know you and what your unique situation is and put you in touch with the people that are going to help you get to your best beyond. I'm going to put my contact information in the chat so you know the telephone number that's ringing is me. I'm a real person, not a bot. And if you're not available, I'm also have a calendar link and I would love to schedule a time to speak with you. You're going to hear a lot of great information. So as Bob always says, get a piece of paper and a pencil so you can take some notes. Thank you.
Thank you, Mandy. Thank you, Mandy. Also, before we begin the presentation, there's not a lawyer on today. And so we don't answer legal questions. And quite frankly, the lawyers, because this is a national presentation, they won't actually answer very specific legal questions when it comes to documents and things of that nature, because can be state information that's required in those areas. We will be talking about specific items that you need to address and et cetera, but not necessarily if my ex does or soon to be ex does this and I'm doing this. What's the legal ramification? That's a maybe. We don't know, and we in Vesta we'll have Vesta get to you and saying we'll get the right attorney to talk to you and be able to give you that info. So for right now, I'm going to turn it over to Susan, and she can kick this off.
Great. Thank you so much, Bob, and appreciate the introduction about SDP and the work that you do. As a life, relationship, and divorce coach, I've been involved with Vesta and connected to SDP and to Bob for many years. The work I do with my clients really benefits from their willingness and ability to work with a CDFA. It makes such a difference. Most people hire attorneys right away when they're thinking about divorce, which is important because you need to obviously go through the legal process. What I appreciate about the CDFA work that Bob and Glenn and their team do is that they're helping you come up with settlement options in the divorce process and also looking at what your financial needs and goals are for the future and making sure that whatever you're agreeing to is going to meet those needs and goals for the future. Whereas an attorney's job is really just to get you to an agreement. So it really is valuable to have the right team. And I know from my work with clients, Bob and Glenn and the folks at SDP do a really great job. I'm going to just speak briefly, just to talk with you a little bit about how to get through, from an emotional perspective, how to get through the process in the best possible way and be set up to thrive in your life after divorce. Some of you may be in the early stages of divorce. Some of you may be in the thick of it, and others of you may be post-divorce as well. You know, what's really important is trying to get through this process with as much confidence and peace of mind as possible, making sure, as I said, that you're set up to thrive after divorce. One of the things that is really important for people to understand is that it is critical that you be able to make sound, informed decisions in this process. What we know in divorce is that you're going to have a lot of emotions in the process and post-divorce as well. That's okay. Our emotions are just understandable reactions to situations. And having strategies for managing those emotions is the part that's essential, because what we know is that when people make emotionally driven decisions in divorce, it tends to make the process last longer, cost more, be more stressful and not necessarily result in the best possible outcomes for you and your family. So, really understanding how to manage all the emotions that you have will help you get through this process and help you on the other side of divorce as well. The question is, how do you do that? So, one of the things I talk a lot about in my webinars and with my clients is about mindset, which is about how you think about things. And how you think about things affects how you feel, it affects what you do, and it affects outcomes. So, indirectly, how you think about things in this process, yourself, your spouse, your family, your professionals, the legal system, divorce, life after divorce, your future, all of it, how you think about all these things now and along the way can indirectly have an effect on the results that you get. It means that your thoughts are really important. And so, to that end, I just encourage you to evaluate them. How are you thinking? It doesn't mean that you have to just feel or think in a positive way about everything. You're likely going to have a lot of other thoughts along the way. So you want to honor those thoughts, and you don't want to get stuck in the more negative thoughts or the negative or whatever thoughts you're having that may not serve you very well in this process. You want to be able to make those informed decisions about your assets, about your children if you have them. And it starts really with how you're thinking about things, again, which affects everything that follows: feelings, actions, and results. I talk a lot about language. I think the words that we use are really powerful. And I'll give you a quick example. I happen to be divorced as well. It's my experience is part of what drives my passion for doing this work and helping people get through it in the best way possible. And when I got divorced, I was living far away from close family and friends. I was moving back to Massachusetts, where I had grown up and gone to college, but had not lived for over 20 years. And I was starting over both personally and professionally. And I remember thinking to myself that I have a choice. I can either say, oh gosh, I have to start over, or I can say, I get to start over. And the difference in that one word, in that phrasing, have to versus get to, completely changed everything that followed. One word changed everything. Now, it doesn't mean that starting over wasn't challenging or daunting, because it was. And it was cool and exciting. Not everybody gets to start over midlife. Not what I had planned. Like a lot of people had a straight line vision for what I thought my life would look like. And of course, like a lot of people, life took lots of twists and turns and led me right here today, actually sitting here with all of you. I actually just shared another example in what I said. I very intentionally said that it was daunting and it was cool and exciting. And I intentionally used that word and there instead of saying it was daunting, but it was cool and exciting. And the reason is that when we use the word but in that context, it actually diminishes or even negates what comes before it. And those feelings that I was having were not mutually exclusive. I was feeling all of it all at the same time. And acknowledging and letting yourself process all the different emotions you may have in the process is an important part of getting through it with that confidence and peace of mind that I mentioned earlier. Along with how you're thinking, pay attention to the words that you're using with yourself, and about all the different pieces in your life here, because our thoughts and our words are very powerful. One other thought is just, as much as we'd like to think that we can change or control circumstances and people in our lives, unfortunately, we don't have that ability. What you do have control over is whatever is in front of you. You get to decide how you're going to respond to whatever is presented to you. And that's actually where your power is. It's not in trying to make your spouse communicate differently. It's not in trying to get the system to respond or process things differently. It's in looking at what's in front of you and making that choice, conscious choice, intentional choice about how you're going to respond to it. And again, that is truly where your power is. And what I mean by that is that's what's going to help you to feel more empowered in this process. And that's really important. For those of you really who are transitioning into that next chapter of your life post divorce, and even for those of you who are early in the process, for most of us, divorce is not where we're expected to be. And we certainly, those of us who do this work, have a real understanding and appreciation for just how challenging it can be. At the same time, I think about when life is going along smoothly, we just go along for the ride. We don't really stop and think about it. We just enjoy it. It's when we hit those bumps in the road, and divorce is a really big bump in the road, that we pause. It's often when people reach out for help. Those bumps in the road are also opportunities. If you're in the thick of it, it might be really hard to take this part in. And it is really true that when we hit these challenges in life, they do provide an opportunity for us to pause, to reflect, to change, and to experience personal growth. And it is possible to get through this process and get to the other side and create a life for you that might be even better than better than you imagined. Again, how you do that is making sure you're working with the right people, paying attention to mindset, having good strategy, getting professional help if you're stuck, certainly in the emotions, paying attention to the community who you surround yourself with, also how you take care of yourself as well, and getting educated. We know sometimes it can take a lot to get to an event like this, but getting educated is really crucial and is part of what helps you make those informed decisions that you need to make. So as you're moving through this process and working on getting to your post-divorce life, and Glenn and Bob are going to talk about their specific pieces around that, keep in mind these things that I'm talking about, because big picture, it will help you. It'll help you work with the professionals that you've hired. It will help you with your decision making throughout, and it will help you get to that next phase of life in a way that really, truly allows you and your family to thrive. So thank you so much for listening. And I'm going to hand it over to Bob.
Thank you, Sue. And something I forgot to talk about when it came to SDP is that SDP, in addition to being very unique in the dealing with the financial aspect, SDP has 4 divorce coaches and relationship and life coaches on staff. And that part of our working relationship with our clients is that they get 2 hours at no cost to meet with our divorce coaches, to work 2 hours with them as well. Take advantage of it. I can't, I'm going through my own divorce. Years ago, I wished I had somebody that was giving me some guidance, some reassurance, some strategies and techniques to use during that process, because I would have stayed more focused on my negotiation of the financial pieces versus the way I handle it. And this is how, unfortunately, most people going through their divorce process allow their emotions to get in the way of the financial decisions that are being made. And we see so many mistakes that are made during that time, both from I just want this done and getting over with, I'll just give everything up. That's usually a big mistake. Or I'm fighting over this blanket that's $50 and I'm spending $5,000 on my attorney to fight over a $50 blanket. So these things can be really kept in their silos with the work of a good divorce coach. And then post-divorce and dealing with your relationships and really understanding, quite frankly, all of us is where we'd like to say that it was just our spouses that were the problem, but we were involved with that in some level. And so working on our stuff and understanding why we're in those relationships are really important. And Susan does an amazing job. And so
Thanks, Bob.
thank you, Sue.
Thank you. Thank you.
And next up, we're going to have Glenn come up and we're going to start talking about the things of the do's and don'ts. And I just things that you should be really aware of when it comes to divorce and estate planning. Glenn, I'm gonna be on the back side here. I'll jump in every now and then. Go right ahead.
Thank you, Bob, Susan, and Mandy, and welcome all the attendees here today. I work with Bob, actually a couple of his firms. Strategic Divorce Planning is where we are today, and we help people become informed and be able to make informed decisions about their future. And we don't care what decision they make as long as they understand the impact of it. So we provide clarity, comfort, and confidence in the area as you go through divorce. But that's not where it stops. It also goes into life after divorce planning, because you're a partner in the firm when you're and divorcing from the marriage, and then you're the CEO of the bank of what I like to call YOU and post-divorce. I want you to First, I applaud all of you for being here, and I want you to give yourself a pat in the back, because whatever you're going through, either you've already gone through divorce and you're doing life after divorce planning, or you understand that it's coming. So you're looking ahead, and establishing a living will and trust is part of a well-founded financial game plan. So when Bob work with people on our firm. We're not going to be like Prince's manager or Aretha Franklin's manager. We want to behoove them to set up their estate planning. It's very important. It's going to be, I'm going to start sharing my screen real quick. Give me 1 second. I know we have a lot of people registered and from around the country today. And we do work all over the country. We're not encumbered by state lines. I'm going to fly through some of these slides given the time today, but Mandy will be following up and she'll allow you to set a appointment or share a calendar link on my calendar. And we can do essentially basically a discovery meeting and I can share more of how this works. So we are looking at protecting your family's future. This is an educational workshop. I'm going to say a disclaimer in just 1 minute. I am a CDFA, as I said, just like Bob. And we're going to talk about living wills, trust, advanced medical directive, financial power of attorney, just how that all fits together. Let me see if I'm using a new tool and let me see if this is going to, okay. You can tell this slide wasn't done for me. I did this slide real quick, but neither the firm Strategic Divorce Planning or its representatives are legal professionals, okay? This presentation is to be considered general, educational, and informational only. It's not intended for any specific legal advice. Please consult an attorney for that. Why estate planning matters, okay? I have been myself a participant in a couple of cases that went to probate. Probate is absolutely no fun because generally the state will take about maybe up to a third of what's in that estate and court costs, legal fees, and other fees. And it takes a long time for the beneficiaries to get their benefit. It can take a year or 2 years for that to happen. Also, people can come out of the woodwork and make a claim. So probate is something you want to avoid. If you don't have an established living will and trust, I tell people don't worry about it. The state will do one for you. You probably don't want that. When you have a living will and trust, also, your estate does not become public information. When it comes public information, I can tell you again from firsthand experience, there's all kinds of people come out of the woodwork. I had people coming to me saying, hey, Glenn, we think you've got a position in this estate and your position is worth $200K. It's going to take 2 or 3 years for them to pay everything out. How about we give you $35K today and buy you out of your position? And there was people that was in my family, some of them fell prey to that. So establishing your living will and trust maintains the privacy. It's not public record. It reduces the stress for your family. You want to make sure that there's the orderly dispersion of your estate as you want it. It can do all sorts of things like provide specific bequests for charities or special situations or different needs you have for kids, loved ones, or whatever. Also ensures the guardianship of minor children is clearly stated and taken care of. All right. Understanding probate. Probate is a court-supervised process of distributing the assets of an estate. There's attorney fees, there's executor fees, there's court fees. Public documents are disclosed about the family's finances. That means, again, as I said, there are firms out there, they make a business out of looking at public records, and then they can come to one of your heirs and say, hey, Johnny, I got a piece of land down in Florida that's covered in swamp I want you to buy.
There for one thing, and because you said something really important there, is that they come out of the woodwork. And why people come out of the woodwork? Because as a part of the probate, an attorney is going to go out to basically the world to find out if there are any relatives that have any claims on the estate. Even though there's a will, the will is a nice document, but a trust itself kind of avoids that. It completely avoids that. And I can tell you firsthand that you get worried about, oh, who could come out of the woodwork? I had a client that passed away, 65, almost 70 years old, and she had no children and no brother. Her brother died, no parents, and she wanted it all to go to her nieces and nephews for college. Somebody in South Carolina made a claim on it because of this attorney putting it all up there. This 90-year-old woman who was living in claimed and took all the money. never met this woman, never knew who this, and quite frankly, to this day, it feels awful because I just feel like this poor woman that passed away, her money was stolen. And so it's like this is a really, I mean, you never know until it happens, and it's a really important aspect. Thought I'd just add that in there. Thanks.
Thanks, Bob. And I've got my video minimized. If you want to jump in, just do it like you did before. Just go ahead and hop in. In any case, and Bob mentioned a couple of things. We'll talk about wills and trusts and wills and trusts and so on and so forth here in a minute. But in any case, we don't want you to be exposed. We don't want your family to experience things that Bob mentioned. So we're looking to take care of folks not only through their divorce, but in life after divorce. And it is criminal. And I decided a long time ago, and I have many examples. I have people whose houses burned down. I'm in California, whose houses burned down, thanking me profusely. I'm so glad we did that living woman trust. And the way we do it, even though they don't have the physical binder, they can still get all the information. Everything is still intact. So this is a very important step that just don't sleep on. Okay. Why estate planning matters. It avoids probate. And we've already touched on that. Probate can take 2, 3, 5 years. It's not a quick process. And it prevents the court from having an involvement in distributing your assets. Your assets will be distributed as accordingly to as you've outlined in your living will and trust. It's private, so it doesn't become public record. You don't have all these other firms coming out of the woodwork trying to prey on your beneficiaries.
So just imagine that someone died and you were the beneficiary of this will and it needed to be probated. And the person that died was actually helping you from an income standpoint or whatever it may be. But if that person died, that all of those assets are frozen for that period of time until it's probated. So let's say, for instance, there was money in an investment account, $500,000 in an investment account, and person passes away and the market tanks. If there's not a power of attorney that supersedes all of that, and then usually this is what happens, and Glenn will talk about this in a minute, but there's nothing that financial advisor or company can do. So you can't oversee it. So it's a really, and no exaggeration, 9 months, 10 months, year, 2 years, 5 years to get some of these cases probated. Go ahead, John. Go ahead, Glenn.
Okay. I just keep reiterating, and Bob is reiterating as well. Okay. We want to work with people. We work with them during divorce, understanding the decisions, how to make the decisions, the impact on those decisions in their life after divorce. We work with them in life after divorce. And the last thing we want to do is leave our clients and the people we work with exposed to probate. So that's why this is so very important. Let's go to the next slide. If I can get there you go. Does it go back? There you go. Let me see if, wow, I went, okay, excuse me. My slide just went, there you go. There you go. Okay. What's a living trust? All right. Living trust it's an entity that holds your assets. You control the assets. Now there's a couple kinds of trusts. There's actually many kinds of trusts, but generally for most families, it's a revocable living will and trust. Why revocable? Means you can make changes to it. Means you have authority over the assets in it that you commit to it, like your house or other assets. Irrevocable is another structure. It is generally used for people that have a high net worth and they want to take care of estate taxes in some point in the future so that their heirs don't have to sell properties or liquidate assets in order to pay estate taxes. And that's a different subject. In the irrevocable trust, you lose control as well. Once you put stuff in there, you can't make changes. So a living trust is a legal entity that holds your assets. You control the assets during your lifetime. The successor trustee manages upon your incapacity or your death. It essentially ensures a smooth transition of control of your assets, and it prevents probate. I'm sorry. I'm using this new tool. I'm using Canva, Bob, so we haven't, okay. All right, so here's the structure, and I'm going to fly through some of these in the interest of time. We can add some more questions. But the person who establishes the trust, that's the grantor. That would be, say, you. And by the way, Bob, you and I have a case right now where we're working with one of our participants, and they needed the living will and trust established because they wanted to put some assets in there where our client could have control of, and our client transitioned to another life in the middle of it, and all the things haven't been transferred, and we're working with her trustee, who is charged with carrying out things according to her wishes, and they're so happy that we did that. I have people, again, whose houses burned down, and they have a living will and trust, and it makes me know that the work that we do is so meaningful. So there's the grantor, there's the trustee, and then, of course, you would name a successor trustee. So generally, if you were a married couple, getting divorced, but it was a married couple, usually one spouse is the other spouse's trustee, but if they're both on a plane or a boat or whatever and both went down, they would have a successor trustee, and then you have your beneficiary. This structure basically creates a smooth flow of authority across all your life's events. What a living trust doesn't do, it doesn't automatically protect you against creditors. So you can't have a revocable living trust and it's impenetrable, but your information doesn't become public, and that is huge as well. It doesn't eliminate your taxes, it's not tax shelter. It must be updated when you have specific major life events. And you really need to fund it. You can't have the trust or you shouldn't just have established a trust and then you don't commit the assets that need to be committed to the trust, like a house, like other things that don't have a named beneficiary. And one of the things that we do, we facilitate this whole process. We work hand in hand with a firm called Estate Guru. They have attorneys all over the country except in Louisiana. And we help facilitate that process, which means we help you get everything established with the living will and trust. And once you've done that, we can help hold your hand to how you get different assets committed to the trust, because there's different processes for those things. And not all assets need to actually be in the trust. But
So, and with that, Glenn, with that one there must be updated after major life events. Here we are, we're talking about divorce. And so that's a major life event. Most trusts will have some kind of language in there that says in the event of the divorce, the trust is null and void. It just gets wiped out. In most states if it's not in the language, most states will not accept it as a legal document if there's been a divorce in them. But that doesn't mean that you shouldn't, at the time of the divorce, when your attorney telling you can do this, is to either eliminate that trust or make sure that it's amended to reflect what the current circumstances are today. Just a really important thing, both when you're dealing with divorce, it is essential that we'll talk a little bit more about beneficiaries in a minute, but specifically with this trust, it's really important to make sure it is eliminated. Most documents do that for you in the wording of it, but but a lot of times what happens is that people don't pay attention, think, oh, it's been eliminated, but the rest of the trust is still there. No, you really need to get this updated. You really need, and most likely it's just going to need to be changed just as a note. So go ahead, Glenn. Sorry.
yeah, it's no worries. It's not only having living will and trust, it's having everything else with proper named beneficiaries. So I too, like Susan, Bob, and Mandy, not everybody, we all have had a previous life where we were married. Okay. And I'm remarried and living a great life. I divorced at 60, so I can tell you how old you are. You just don't know what's going to happen. And I never thought it would happen. And I'm so grateful that it did. Now I'm 71. One of the things, though, was that I've got two bionic knees. I played football in college. I got two bionic knees. I'm sure glad I reestablished my living will and trust so that my ex's name wasn't on my advanced medical directive. Because I might have gone in there and had some complications. Who knows what she might have said. So we want to make sure we do this. Understanding a will, it directs the distribution of your personal property. It names guardians for your children. It still requires probate. So that's why people say, we only need a will. You don't need just a will. You need a will and a trust, or I would suggest, I try not to tell people what to do, but I would submit that you need a pour over, what they call it, a pour over living will. It means that upon your death, the will pours over into the trust, and the trust follows the directions of the will along with other things that are established in the trust. So if you just have a will, you can still go to probate. And portable wills will move unfunded assets. So if you have assets, for instance, I have guitars. I got 26 guitars or whatever. People have art, rare or jewelry, these type of things. These are things that you don't have a named beneficiary on a sheet of paper like an insurance policy or an investment account or one of those things, but you express these things. It pours over into the trust. Let's see if I can get to the. I am not. I'm sorry. I'm sorry about that. There you go. Okay. An advanced medical directive, advanced healthcare medical directive. Again, what that means is that you would name someone who's your agent. You all of a sudden got to go to emergency, and my next door neighbor here, ambulances were out here and took him out of here in the ambulance. Okay. So you want that advanced medical directive so that your spouse, not necessarily, I'm sorry, not necessarily new spouse, but whoever it is, your oldest, the most responsible child or your best friend or whatever, is named as your advanced medical health care, power of advanced medical health care. Meaning if you were in there and something happens and they're trying to revive or resuscitate or whatever, or make some major decisions, you have someone else that has been appointed to help you with that. HIPAA authorization is the healthcare information protection. I can't call the hospital and ask to see my wife's or my son's or anybody else's record without the authority. So the person who is named on your advanced medical health care directive would be the person also that has authority to see information and speak to doctors and practitioners on your behalf. A durable financial power of attorney. This is someone who has the financial power of attorney that is generally the trustee of your named trustee in order to make financial decisions on your behalf. But this is only in the case that you become incapacitated or because of your demise. It prevents, again, the court taking conservatorship of these assets and whatnot. And it's also something like all your living will and trust and advanced medical directive, financial power of attorney should be reviewed every so often, and particularly with life changes. The documents all work together. The living trust handles your asset management. The will handles guardianship and asset instructions. The medical directive handles your medical decisions. The HIPAA gives the successor the ability to see your information. The power of financial attorney is for your financial management. And all these things together, that's what complete living will and trust or estate protection plan is for you.
Just as a note, Glenn, on that financial power of attorney, whether you have a trust or not, if you have accounts right now at the bank, at an investment house, in your retirement, you should have a power of attorney, and your house, dealing with your house. You should have a financial power of attorney, even if you're not going through divorce. It's really a very important document, and if your advisor hasn't asked you for that, shame on them. You really should make sure that's on file because you just don't know what you don't know is going to happen, and those are really important documents to have. Big quickly.
Common mistakes. Okay. And we're talking about life after divorce planning. Again, you guys give yourself credit for being here because you're in the game right now. You're in the game, maybe a battle, you might call it, going through divorce. The post game is coming up. The interview's coming up after the divorce game where they're saying, hey, Bob, hey, Sally, how'd you do it? How'd you make that play? And you're looking at your life after divorce. You're setting yourself up for the post game. And common mistakes that people make is relying only on a will. I mentioned before, that's not enough. By unfunding their trust. Some people establish their living will and trust and then they don't fund it with the things that needed to be funded with. It doesn't mean you lose control. It just means they're named in the trust. There's documents that become outdated. There's missing incapacity planning, whereby there's not clear directives on what happens if you become mentally incompetent or physically unable to do things. They don't have a trustee name. They don't have access to these documents digitally, and this is a huge thing. So our firm, again, has a partnership with another firm called Estate Guru. They have attorneys all over the country, except in Louisiana. And one of the things I love about our service is that not only do you get a physical binder, but I have people and know people who have their physical binder, their trust and will, and they don't know where it is, much less their confidants, their successors, their trustees know where it is. In our service, you not only get the physical binder, you also have access to these documents digitally, and you can make changes easily as well. We work with a state guru, as I said, 49 state coverage. It's very streamlined. It's a very guided process. It's affordable. It's not expensive. It's much less than on average than working with an attorney. You get the physical binder. You get access to it electronically in the digital portal. And updates are available at a low cost. So the way it would work, if you schedule an appointment with me, we'll have a brief discussion. I like to do virtual meetings. I don't like to be just a voice on the phone, but I'll spend 30 minutes with you and learn a little bit about your situation. Hey, if your net worth is $100,000, you still need a financial power of attorney and advanced medical directive. In fact, if you make an appointment and we do that in 30 minutes, we can do the financial power of attorney and the advanced medical directive for you. And we'll do that for you at no cost. The living trust and will is something that we will do, and there is a cost with that. So the full package for the trust and will package is $13.98. That's extremely reasonable. The property deed, because you need a deed that names your property to your living will and trust. It needs to be recorded with the county. That's $198 per household. So if you have 2 households, then you got almost $400 for property deeds. It includes the trust, the will, the advanced medical directive, the HIPAA release, the power of attorney, financial power of attorney, and medical power of attorney, and all the other documents like areas for your personal directives. And some people I'm 71. When you get to 71, you've collected some things, whether you knew you were a collector or not. You might have a collection of watches or guitars or whatever it is. Let's see. I'm looking at time.
I'm gonna just jump in I think we should go to a few of these questions, Glenn.
Okay.
Some very good questions that I'm not going to answer privately because I think they're perfectly written and can help everybody. One of the questions is what can and can't go inside revocable and irrevocable trust. Again, we're not attorneys, but just about everything can go inside a revocable trust and irrevocable trust. It's a matter of how you want to use the trust, and that's something you can really determine with your estate planning attorney, as we do is with a state guru, et cetera. And so open as a part of that is, in other words, can you borrow money from a trust? If it's irrevocable, inside the trust might say a person, you can receive money from the trust in various ways. And so they can create it as I don't want to say loosey-goosey, but loose and or very restrictive. The thing that's restrictive about a irrevocable trust are the beneficiaries. The beneficiaries, you cannot change them, and they will benefit from your passing going forward. But while you're living, there are ways to be able to use the assets, buy and sell the assets, add more assets into the irrevocable trust as well. When it becomes revocable, you can do anything. Its money is in and out, and there's no real restrictions there when it comes to those things. And it's why you don't get any tax breaks on it. It's why it doesn't circumvent the state tax laws or anything like that. So you can create things as kind of loose as best as possible and restricted as possible. Should this be done by a lawyer? 100% yes. That is a 100% yes. Are there any special clauses to be included to protect your assets from being given to an ex-spouse and his new wife or kids or on your death? So again, there are definitely different things that can be added to your specific situation. Again, need to talk to a specific divorce attorney in those processes, as well as the estate planning attorney. Another question: why would I need a financial power of attorney if I have a POD or a TOD, transfer on death, payment on death, bank accounts, and retirement? So yeah, you really don't need one for kind of the death aspect. Really, why you need them is when you're incapacitated, you're unable to make decisions. So if you get in a car accident and you bump your head and you're not able to make any sound decisions, nobody can make a decision in that. You're alive. Nothing's going to your beneficiaries. No, that the POD and the TOD, the payment on death or the transfer on death, is not going to happen. So that financial power of attorney give someone the right to represent you to make sure that your assets are being taken care of in that moment. And that can be stipulated as to exactly which assets and what they can and can't do. You can do lots of things with that. But I can't stress enough how important it is. I literally have been sitting on my desk, a dear friend and client of mine that passed away a year ago. They just resolved the probate portion of that, and I could not touch his assets. When I look at it on my screen, it says restricted. There's a big R on it, and it says and restricted doesn't allow me to make any transactions inside that account because of that. So I can't stress that enough, having that. And then lastly,
But we have our asset funding guide that we send, that we help people with. So you click on that and we're there to help them, but tells them if this is an asset that is typically or should be not committed to the trust, because there's some things that have named beneficiaries that as you said, there's no problem with that. They all need to be identified.
next question. If you have a revocable trust, why do you need all the other stuffs like living trust or wills or directives? The revocable trust, it can include the will as a part of it. The will, it just gets referenced as a part of it. So the will just basically says, here's what I want to have happen. The trust says, here's the legal part that we're going to bypass probate because of the legal aspect of it. So that's why having it is really important. Directives, like medical directives and financial directives, those are again about while you're living, and in needing those when you can't make your own decisions is imperative. In that, as a matter of fact, when you go into the hospital, I don't know if you've, unfortunately, I've had the luxury of going into the hospital a bunch of times in the last couple of years. And one of the questions they ask you is, do you have a medical directive?
They absolutely.
They ask you when you walk in. So that it is really important, and and the ones that don't even know what that is, they'll ask, "What is that?" kind of thing. And those that have had it done know they have it, and it's really important that the hospitals know. So these are not to be taken lightly. They're really important. And when do they become important? Unfortunately, in the real difficult life transitions of people, in a serious accident, in a illness, in dementia, Alzheimer's, all of these kinds of things that we can't really see happening, and then they happen to us. And if you don't have something in place, it becomes really problematic. And then another question is, can an IRA be in a trust? Technically, it can, but that's not how we manage it. So IRAs are really nice because they all have beneficiaries associated with them. And so because the IRA has a beneficiary to it, that in and itself bypasses probate. So that's a really good thing. However, what we typically do is that if a person has a trust, that person usually is talking about their entire estate, not just one asset or one item, not one IRA or one bank account. They're usually talking about their whole estate. So what we typically do is that IRA, the beneficiary, will be the trust. So when the person passes away, that trust will oversee that IRA and its distributions to that. I think we have, okay. Can you speak to what can be done to ensure assets are protected for minors? Should you list the minors as beneficiaries excuse me, it must be bank accounts, not bank accounts. So minors are minors. They don't have a lot of rights, and like they can't be on an account by themselves. It's that in itself. So that's one problem. That's why trust is so important to have, especially around minors, because then it will discuss, if I do die and the beneficiaries, my kids, are minors, how is that going to work for them? So as a part of that, you create financial trustees. You might create guardian trustees that are going to take care of their health and well-being. And then others, I will tell you, in my own trust, I have one person that's a financial trusted associate that will be dealing with my kids in that case. And I have a medical person. So it's very different. And because I see that role, those roles as being really different and needing different expertise. So having those are really important. So should minors be listed as beneficiaries? Sure, but they're not going to be able to be just what happens is that you really should have an adult as to being a person. The trust circumvents all of that. That is the important part because now everything that you have can be the beneficiaries could be listed as the trust. And then the only thing anybody has to do is whoever your trustee, or most people would understand executor, but it's really the trustee of the trust, will be able to really look at it very clearly and know exactly what to do with all of those monies and how to protect your children as a part of that.
Bob,
Yeah.
let me interject you real quick because I know we're at time. I need to explain to people how it works. We do a meeting. You set up a meeting with me. We'll have a 30-minute meeting. I'll help understand, well, what are all the pieces? Is this something that, makes sense for you? 95 times out of 100, it does. I'll explain the process. If it's something you want to go forward with, I'll send the package, the meeting prep package, so that you know the kind of questions I would ask. Afterwards, we will have a 30, 40-minute Zoom session where I'm intaking that data. I'm uploading that information into the Estate Guru portal. 7 to 10 days after that, you'll receive the binder. The binder, by that, the trust and will, the advanced medical directive, the financial power of attorney, along with instructions on what pages need to be signed, notarized, and whatnot. Once you have done upload those documents into the portal because you'll now have access into your case file in the portal. And I have a gentleman, Bob and I have a client. He's a coach actually he's a coach in Louisiana, but he has a home in Indiana. So we were able to do the living will and trust for him. And he said, Glenn, hey, I uploaded the documents and I checked the next day and I can look in the portal. Everything is completed. Everything is established. So now you go about the other work of putting in your personal directives and everything. But it's really easy. It doesn't cost a lot. It doesn't take a lot of time. You don't have to get in your car. It's easy to do. So I wanted to be sure I iterated that, Bob.
Yeah, and that's really important. There's one more question I want to address after this as well. But the cost thing. So just to give you an idea, my own personal trust cost me $4,500. It does absolutely nothing more than what I wish we had State Guru around 6, 7 years ago. It would have saved me $3,000. It's really inexpensive, great way to do it, and it just makes a lot of sense. And having it available digitally is powerful. But the way these documents are not small, you got lots of documents associated with that, and sticking it somewhere, hiding it in a safe that everybody doesn't have the combination to. I've seen that many a times as a problem. Last question that I want to address. The person asked me, can you tell us exactly what you have personally? And what are must-haves for us to have as a divorce thing? So everybody's situation is different. So that's important. So for me, when I got divorced, I knew that I needed to have a will and obviously the trust because I wanted, no matter what, whoever my beneficiaries were going to be, I wanted them not to have the hassle of dealing with probate. And please don't take this lightly. That you just watching the excruciating pain that people have with this is really powerful. So it's really important. So yes, I do feel it's imperative to have a trust, a revocable trust. 95% of the people out there don't need an irrevocable trust. An irrevocable trust can come into play as you get much older. Maybe you're in your late 70s and you want to protect all of your assets away from the government when it comes to maybe long-term care issues, things like that. That's a bigger topic later on. So most of us are going to need, most of us are going to need a revocable trust. So I have that. The second thing that I have, which was most important, is a medical directive. Finally got to an age where I'm going, oh shoot, I'm getting sick, and I want who's going to make decisions for me? It's not being. My mother's 86 years old, and I'm sure she would tell the doctor a thing or two, but quite frankly, I don't want my mother to care with me. So I want somebody that cares about me and also has a brain to be able to really deal with that. So having a medical directive is important. And if you have any money anywhere, you need to have that financial directive. Those 3 documents, I think, are imperative post-divorce. They're imperative whether you're going through a divorce or not, but definitely on the post-divorce side, because you're now organizing your life. Most of us, as we're going through our marriages, I was married over 25 years, like, it all blends together and you don't see how it's all working. And then you get through this process, and all of a sudden you realize this is your life. You better organize it. This is a great way. This is like going to the hospital. They're going to ask you, you have a medical directive? No. Really? Well, they may bring you a form. They may bring you out a form and say, we need a medical directive in case something should happen to you. So these are really important things, and they require thought. I never thought they did, but all of a sudden I go, who do I want making financial decisions for me? It's not the same people, a person I want making a medical decision for me. So these are things that really should think about. And you ask the other question, great questions around children and how to deal with them. The trusts really do a great job of dealing with these. And quite frankly, like for the most part, wills and trusts are really boilerplate aspects, and you need to just fill in the open lines to create a trust. And that's why I paid $4,500 for my trust, and today you're paying $1,400 or $1,600 for a trust. And going, how did that happen? It's because they cut out all the kind of the profit that the lawyers were really taking on these things. And so Estate Guru does a really good job saying, you don't need all of these things. We're not going to charge you all these extra hours. Let's get this stuff and get it done. And they do a great job of doing that. So anyway, great questions today from all of our attendees. The Strategic Divorce Planning will be having quarterly national events. So there'll be all different topics. We may even see them increase events over the year, but right now we're planning on them on a quarterly basis. Please take a look at us. We're online, strategicdivorceplanning.com. It's strategicdivorceplanning.com. And get in touch with us. Get in touch with Vesta. They know us really well, and we do a good job. And not just we do an amazing job of helping people get through the divorce process, making sure we do the pre-forensic area is really important for you to be looking at. And take advantage. If you need a consultation, we do free consultations as well to give you an idea about what we think about your particular case, etc. I want to thank both Glenn and Susan for great presentations, and thank you everybody for coming. Look forward to talking to you in the future.
Thank
Thanks,
you,
everybody.
everybody. Thank you.